Jefferson County Court, law number 2 is now in session. Court is in, Mr. Hall, which one of your clients?
They're both here. This is Mr. Honey Lawrence.
Mr. Lawrence, okay. The court is in session and calls number M333930. The case is styled of State of Texas versus Jaime Izzel Lawrence. Mr. Lawrence, is that your full name?
Yes, sir.
How you doing, Mr. Lawrence?
Oh, pretty good.
You doing pretty good? That's good. Now, Mr. Lawrence, you're here represented by your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
Great, thank you.
That's good. Now, Mr. Lawrence, the state is represented in this case by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm well, Your Honor, thank you.
That's good. Now, Mr. Hall, what is your announcement in Mr. Lawrence's case?
Your Honor, I have spoken to the, Mr. Johnson a couple of times, one other time, and then today. We're having problems with the new Odyssey system, downloading Discovery. Hopefully, if we could have a 2-month reset, because he took, he's got to go to work and everything. We could dispose of it on the next setting if they
Get the Odyssey system working. Give us a reset date.
That'll be May 24th.
Okay, Mr. Lawrence, your case will be reset to
Can
May.
we get off a little bit further out, because I know that week I have a personal matter.
Okay.
What about June 7th?
Okay. Mr. Lawrence, your case will be reset to June 7th. Your attorney is going to get a copy of your reset. Once you get a copy of your reset from your attorney, you'll be free to go and you have a blessed day. Please stand on the X next to your attorney. Murphy. Mr. It's Renee
Yes, sir.
Antonio Elias.
Yes, sir.
This is cause number M 332-300. Mr. Elias, are you represented by Attorney Doug Murphy?
Yes, sir, I am. I believe that he was supposed to be here. before.
Okay. Just go have a seat outside and we'll see if we can, we'll wait for him to arrive.
Okay. Thank
All
you.
right, all right. Jefferson County Court at Law number 2 is back in session. Court is in session at cause number M333036. Case is style of State of Texas versus Crystal Mayfield. Ms. Mayfield, is that your full name? How you doing, Ms. Mayfield? I'm doing fine. Thanks for asking, Ms. Mayfield. You're here with your attorney, Attorney Kyle Walker. Attorney Walker, how are you doing?
I'm good, Judge. How are you?
I'm doing fine. Now, Mr. Walker, what is your announcement in Ms. Mayfield's case?
Actually, Judge, I think the state's going to have an announcement on this one for.
Yes, Your Honor.
Okay, what's
We're
state's now?
requesting us for reset on this case, Your Honor. I just need to, I believe we can dispose of this case, Your Honor, but before I need to walk about it, I need to talk to the victim in this case, Your Honor.
Okay, how much time do you need?
2 weeks would be,
Okay, give us a reset date.
if that works for Mr. Walker. Good.
Yes, sir, that's fine.
Okay,
Judge, I'm actually free the 19th if that's.
That is.
All right.
okay. What date is that? That's
April 19th.
April 19th?
Yes, sir.
Okay, Ms. Mayfield, she's on the bottom of page 5. Ms. Mayfield, this case will be reset to April 19th, 2023. Your attorney is going to be given a copy of your reset date. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. Please stand over here in front of our court coordinator. You are. Yeah. Yeah, she has a 2 possession of controlled substances, class A. Hmm. Ms. Walker, you ready on Sharonda Garrett?
Judge, on that one, we're waiting because I think that was Mr. Hoffpower.
Okay, okay, we'll hold on it. And Mr. Macon, are you ready on Jason Chandler?
Yes, Your Honor, that's going to be reset to trial.
Okay, Mr. Chandler, would you come forward? And Mr. Bailiff, would you please see if Brian Goldman on page 4 is here? He did not, okay.
He should be zooming in, Your Honor. I'm saying.
This is,
This is also Kobe's cases.
oh, it is?
Yeah. If
Okay.
you don't mind having.
Okay, I'll hold. Jefferson County Court at law number 2 is back in session. Court is in session at cause number M331658. The case is Solid State of Texas versus Sharonda Garrett. Ms. Garrett, how are you doing?
I'm good.
That's good. Ms. Garrett, you're here represented by your attorney, Attorney Kyle Walker. Attorney Walker, what is your announcement in Ms. Garrett's case?
Like the last case, Judge, I think the state's gonna have an announcement.
Yeah, Your Honor, if we could set this on, the 19th is,
The same day?
Yes, sir.
well, I probably want to set it on the pre-trial docket, but it looks like the 19th is 2 weeks from today. So I guess, yes, sir, we can reset it on announcement of it.
Okay. This is gonna be on the same date. This is Sharonda Garrett. Cause number, she's on the bottom of page 5. Second one from the bottom.
Okay.
Gonna reset it on the same day of April 19th of 2023. Ms. Garrett, your attorney is going to get your reset from our court coordinator. Once you get your reset, once he gets your reset from our court coordinator and give it to you, you'll be free to go and you have a blessed day.
Thank you.
Please stand over in front of our court coordinator.
Thank you, Judge.
You're welcome. And Mr. Walker, you'll be free to go as well and you have a blessed day.
Thank you.
Are we ready on Mr. Goldman? He's on Zoom. Next case is cause number M329730. Case is style of state of Texas versus Jason Oliver, excuse me, not that one. Well, the cases, well, we have 2 cases. Cause number M326042 and cause number M326044. Both cases are style of state of Texas versus Brian Joseph Goldman. Mr. Goldman is appearing via Zoom. Mr. Goldman, how are you doing? Must not have his volume on. Mr. Goldman, can you hear me? Mr. Goldman? No, he was there earlier.
Yeah. Isn't that his head there, the top?
Yeah, it is. And it's kind of blurry right now, but. Okay, Mr. Goldman, you're here represented. Probably not, hold on a minute. No. I see what it is. He hadn't connected to, he's not connected to the audio. He's not connected to the audio. Mr. Goldman, you need to connect your audio. If you can hear me. Now, Mr. Goldman is represented in his case. Oh, he's connected now. Mr. Goldman, can you hear me? Your mic is on mute. Your mic is on mute. Take your mic off of mute.
Can you hear me?
Yes.
Now, yeah.
Okay,
Mr. Goldman, how are you doing?
doing pretty good.
That's good. Now, Mr. Goldman, you're represented in your cases by your attorney, Attorney James Macon. Attorney Macon, how are you doing?
I'm doing wonderfully, Your Honor.
That's good. Now, Mr. Macon, what is your announcements in Mr. Goldman's cases?
Your Honor, Mr. Goldman goes to trial in Williamson County in the 277th District Court on Tuesday, the 11th. And once those are over, I think we'll be able to talk about these cases. We could have like a 2-week reset.
Okay, give us a 2-week reset.
April 19th.
Mr. Goldman, your cases will be reset to April 19 of 2023. Your
Okay.
attorney and your bondsman will be given notice of your reset dates. Stay in contact with your attorney and your bondsman. You're
Yes, sir.
free to go. And
All right.
thank you, and you have a blessed day.
Yes, sir, you too. Thank you.
You're welcome. And Mr. Macon, James, you got Jason Oliver Chandler.
Yes, Your Honor, he's present.
Would you, Mr. Chandler, would you please come forward? The court is back in session and calls number M329730, case of South State of Texas versus Jason Oliver Chandler. Mr. Chandler, how are you doing?
I'm doing well, sir. How are you?
I'm doing fine, thanks for asking. Mr. Chandler, check and see if, Mr. Chandler, do you have bond conditions in this case? Are you required to have an interlock device on your vehicle?
Yeah, near my device.
Okay. Now, Mr. Chandler, you're represented by your attorney, James Macon. Attorney Macon, what is your announcement in Mr. Chandler's case?
Your Honor, at this time, we're going to announce trial, but I understand Kobe's now the DA, and I'll talk with him some more, and maybe we might be able to work something.
Okay, give us a trial date.
June 15th.
June 15th of 2023. Mr. Chandler, your case will be reset to June 15th, 2023. Your attorney is going to get your reset. Once you get your reset from your attorney, you'll be free to go. You have a blessed day. And Mr. Macon, I think this is the last case.
It is, Your Honor.
You're free to go as well, and you have a blessed day.
No, the court date is gonna be June 12th.
The trial date is going to be June
Well,
12th. And that's for Mr. Chandler.
Yep.
June 12th.
I have no idea.
okay.
You have that, Mr. Chandler? Your court date is going to be June
We'll
12th.
get on this with that.
Okay.
Can we approach on Mr. Roberts' case? Overall.
Yes, where's Roberts? Corey Roberts. This is cause number M333124. Case of South State of Texas versus Corey Holland Roberts. Mr. Roberts, is that your full name?
Yes.
How you doing, Mr. Roberts? That's good. Now, Mr. Roberts, you're representing your case by your attorney Willard Hall. Attorney Hall, what is your announcement in Mr. Roberts' case?
Your Honor, I was expecting we have an acceptable plea bargain offer to do it today, but Mr. Roberts just informed me that we contested his driver's license suspension. We had an ALR hearing. He lost his ALR hearing. The judge ordered a 90-day suspension. We were under the impression when we came to court today, he'd have his driver's license back because the 9 days was up. He recently informed me that he got notice from the DPS that they were going to extend that suspension out for 1 year because it's a second offense. So what we're going to have to do is we're going to have to get him an occupation license. And before he pleads out in this case, when he goes into probation, he'll be all legally dry. So what we're asking for is a 60-day reset. I'll get him his occupation license. And I apologize.
Okay.
He's been working nights and he just informed.
Give us a reset date. State, you have any objections?
No objection, Your Honor.
Okay,
June 7th.
okay, to be reset to June 7th of 2023. Mr. Roberts. Your attorney is gonna get your reset. Once you get your reset from your attorney, you'll be free to go. And Mr. Hall, I think this is your last case today. You'll be free to go as well.
Thank you.
All right. Please follow your attorney. You have a, need to talk to that attorney over here. Mr. Murphy?
McKinney or Mr. Murphy.
Okay.
I apologize, I was getting the hearing out in the parking lot via Zoom.
Oh, okay.
I didn't realize, Judge, and I'm not sure how you may want to handle this. Mr. Macon's client did not, there was no proof of the interlocutor, like we had documentation about the interlocutor,
Oh, you didn't?
but there was no proof of it.
Oh, okay. We have bond conditions?
We have bond conditions, but I see that they're usually,
You say that was Mr. Who's?
making, last fine, Your Honor. It was.
Is it, hold on a minute. Normally they bring that to the. Hold on a minute. The court is back in session and calls number M332556. Case is style, the state of Texas versus Terry Tyrone Lewis. Check to see if we got bond conditions in this case. Mr. Lewis, your full name is Terry Tyrone Lewis?
Yes.
Now, Mr. Lewis, you're represented in your case by your attorney Bruce Smith. However, Mr. Smith is not present. Does Mr. Brennan Mitchell have your permission to stand in for Mr. Smith? Okay. Mr. Mitchell,
Yes, Judge.
how are you doing?
I'm doing fantastic, sir. How about yourself?
I'm doing great. Thanks for asking. And Mr. Paul Farr, how are you doing?
Good, Judge. Thank you.
Mr. Mitchell, what is your announcement in Mr. Lewis's case?
We were asking for a brief reset, Your Honors, to give the state a little more time to go over the case.
How much time do y'all need?
Regular reset, Judge.
Regular- Regular reset? Okay, reach me the bond conditions. Now, he has a DWI second.
Second.
Here, are you still? No. So you don't have a vehicle that you're driving currently? Have one, but. I think.
It should be. It is.
But I'm saying like, you can like, have a car, turn it around, your daughter gonna still drive your bike. I have. Well, since he doesn't have the license to drive legally anyway.
Well, what would, it's just an order of an.
Yeah.
So that should he in a vehicle driving out.
Yeah.
So,
You'll be ordered not to drive.
Mr. Gurr, can you make a copy of this? Mr. Mitchell, could you hand this copy to you? Mr. Lewis, your attorney, Mr. Brennan Mitchell, has just handed you a copy of a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay, I will go over these conditions with you. And it reads as follows. Following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes.
Now, condition number 3 does not apply in this case. However, condition number 4 does apply, and condition number 4 states, a defendant who has been arrested or accused of any subsequent offense listed under Section 49.04 through 4906 of the Texas Penal Code, and that's where your case is located, shall be not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on before the 10th day, they said after arrest. So, Mr. Lewis, do you understand that condition?
Yes, sir.
Now, Mr. Lewis, if you violate any one of these conditions, your bond can be revoked. That means that a warrant can be issued for your arrest and you can be placed in the Jefferson County Jail. Do you understand that?
Yeah.
Now, basically, condition number 4, you cannot operate a motor vehicle without it having an interlock device. Okay, any vehicle that applies to any vehicle that you own or operate. It has to have this interlock device before you drive it. Do you understand?
Yes.
All right. Now this case has been reset. Your attorney, Mr. Mitchell, is going to give us a reset date? May 17th. Your case is reset to May 17th of 2023. Mr. Mitchell is going to get your reset date and to get a copy of the reset for you. Once you get a copy of the reset from Mr. Mitchell, you'll be free to go and you have a blessed day. Please stand in front of our court coordinator for the reset.
Thank you.
You're welcome. Jefferson County Court, Law number 2 is back in session. The court is in session in 2 cases, cause number M332208 and cause number M332210. Both cases are styled the state of Texas versus Crystal Marie Brown. Ms. Brown, would you please raise your right hand? Ms. Brown, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Brown, you may put your hand down. How are you doing, Ms. Brown? That's good. Now, Ms. Brown, your full name is Crystal Marie Brown?
Yes.
Ms. Brown, your attorney of record is attorney Bruce Smith. However, Mr. Smith is not here this morning. Standing in for Mr. Smith is attorney Brennan Mitchell. Does Mr. Mitchell have your permission to stand in for attorney Bruce Smith?
Yes.
Mr. Mitchell,
Yes, Judge.
how are you doing?
Fantastic, Judge. Thank you. for asking.
And thank you. You're welcome. Now, Mr. Mitchell, do you waive a record in Ms. Brown's case?
Yes, Judge.
Ms. Brown, I have before me a document that is titled Information. This information alleges that on or about February 14th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, possession of a controlled substance. And this is in cause number M332208. Now, Ms. Brown, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Brown, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, Ms. Brown, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Brown, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Ms. Brown, do you recognize this document?
Yes, I do. Yes.
On page 2 of this same document, Ms. Brown, there are a set of initials that are on a line next to a box that's checked NOLA contingent, which means no contest. Did you place your initials on this document?
Okay.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Ms. Brown, is this your signature?
Yes, sir.
On the next document is titled Trial Court Certification of Defendant's Right of Appeal. Ms. Brown, do you recognize this document?
I do.
And is this your signature on the line that is titled Defendant? There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? The discovery certification. Ms. Brown, I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
It is.
Ms. Brown, before you sign and initial all of these documents that I've just mentioned to you, did your attorney, Mr. Mitchell, go over these documents with you?
He did.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Brown, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, which is in the court's file. State, would you like to offer State's Exhibits 1 and 2?
Yes, Your Honor. State offer stage 1 and stage 2.
Any objections?
No objection, Judge.
No objections. State's Exhibits 1 and 2 shall be admitted into evidence. Mr. Mitchell, you advised and counsel Ms. Brown. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Brown, your attorney, Mr. Mitchell, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
He has.
And your attorney of record, Mr. Smith, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
He has.
Ms. Brown, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, in exchange for the finished plea of no contest in this case, the state is recommended that the court defer adjudicating guilt at this time and instead place the defendant on community supervision for a period of 6 months, Your Honor. There's no fine attached to this plea agreement, Your Honor. We're asking for defendants to have 25 hours of community service and to attend and complete a drug offender class, Your Honor.
Or after this initiation, do you want one probation officer? The drug collection. There's something else that comes like, she's already done that, so that makes it that one.
Probably up to the probation on that.
Okay, now what about the second case? Is that part of this?
It's not part of the plea agreement, Your Honor. That's going to be separate.
Okay. Ms. Brown, the state is offering, hold on, let me do this here. Figure this out. What's this? Okay, now, Ms. Brown, the state is offering that you serve 6 months of deferred adjudicated probation. During the 6-month probationary period, you will be required to, well, you will not be required to pay a fine. The fine will be waived in this case. However, you will be required to pay court costs in the amount of $337. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to pay a restitution fee of $15 each month. Now, the total monthly installments that you'll be required to pay, that is the total amount that you will be required to pay while you are on probation, is $160 a month. Will you be able to pay the $160 each month?
Yes, sir.
You will also be required to attend a drug offenders class. And you be required to complete 25 hours of community service. And you will also be required to adhere to the other standard terms and condition of your probation. Ms. Brown, do you understand the state's offer?
Yes, I do.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, I do.
Ms. Brown, I'll follow the plea bargain agreement. Court is going to defer finding of guilt and place you on deferred probation for a period of 6 months with the conditions that the court previously stated. Now, Ms. Brown, if you successfully complete this probationary period, this case will not result in a conviction. It will be dismissed and will not result in a conviction, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Smith or Mr. Mitchell, about the non-disclosure because they're quite competent on those matters. And this will conclude this case. State in cause number M332210. What is state going to do on that case?
Your Honor, the state's dismissing this case, Your Honor.
Okay, you did the dismissal yet?
Yes, yes, sir.
Oh, wait up, I have it here. Okay, now, Ms. Brown, in cause number M332210. The court is signing a dismissal that has been filed by the Jefferson County District Attorney's Office. So this case will be dismissed. You'll be able to get a copy of this dismissal once you follow the directions of our clerk. You're going to stand on the X next to your attorney, follow the directions of the clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
Judge.
You are.
Okay, I'll try again, and if I still have issues, I'll call. Thank you. I'm gonna need to have a seat on my issues. They all should have.
Still have some problems with honesty.
Good, we'll just need to.
Okay, Mr. Mystery, that's your last case. You're free to go and you have a blessed day.
Thank you, Judge. You as well.
Thank you.
Okay, so this is showing out, so let's get this one for this. Okay, I don't. So, okay, I will, do that. Thank you.
Hey, how you doing? Next case is cause number M328882, case of style, the state of Texas versus Justin Philip Mattingly. This is cause number M328882. Case of style, the state of Texas versus Justin Philip Mattingly. Mr. Mattingly, would you please raise your right hand? Mr. Mattingly, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Mattingly, you may put your hand down. How are you doing, Mr. Mattingly? I'm doing fine. Thanks for asking. Now, your full name is Justin Philip Mattingly, is that correct? Okay. Mr. Mattingly, you're here represented by your attorney, Attorney Jennifer Mattingly. Attorney Mattingly, how you doing?
Pretty good, Judge.
And Mr. Mattingly, do you waive a record in Mr. Mattingly's case? State is represented in this case by Attorney Colby Hoffar. Attorney Hoffar, how are you doing?
Good, thank you.
Mr. Mattingly, I have before me a document that is titled Information. This document was filed by the Jefferson County District Attorney's Office. This information alleges that you, Justin Philip Mattingly, on or about November 15 of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 1.5 or more. Mr. Mattingly, do you understand what you have been charged with? And to discharge, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Are you pleading guilty because you are guilty?
Yes, sir.
Mr. Mattingly, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Mr. Mattingly, do you recognize this document?
Sir.
On page 2 of this same document, there are, I guess, the initials on a line that is titled, let me see, it's initials. That's your, it must be your initials. Initials on a line that is titled guilty. You place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled defendant. Mr. Mattingly, did you place your signature on this document?
Yes, sir.
On the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Mattingly, do you recognize this document? And is this your signature on the line that's titled defendant? There's one box that's checked at the top of this document. That box states that this is a plea bargain case and you have no right of appeal. Do you understand that? Now, do we have a discovery certification?
Yes, I do.
The next document I have is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Mattingly, before you signed and initialed all of these documents that I've just mentioned to you, did your attorney, Ms. Mattingly, go over these documents with you? And did you read and understand everything that she went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Mattingly, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. State, would you like to offer State's Exhibit Number 1 into evidence?
Say, will Your Honor.
No objection.
No objection. State's Exhibit Number 1 will be admitted into evidence. Ms. Mattingly, you have advised and counseled Mr. Mattingly. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir.
Mr. Mattingly, your attorney, Ms. Mattingly, has advised and counseled you. Are you satisfied with her representation?
Yes, Your Honor.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Mattingly, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The state's for plea of guilty, Your Honor. The state producer recommend 180 days probated for 1 year, $800 fine and court costs, 60 hours community service, standard DWI conditions, any other terms and conditions deemed appropriate by probation and interlock device.
Okay, well, thanks. Yeah, and other, I didn't see that in the. That's, you know. There's an. Et cetera. I really want that it's-
Mr. Madeline, the state is offering that you serve 180 days in the Jefferson County jail, but you would not be required to serve any time in the Jefferson County jail on this case. You will be placed on probation for a period of 12 months, which is 1 year. During the 1 year probationary period, you'll be required to pay a fine of $800. You'll also be required to pay court costs of $407. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to pay a restitution fee of $15 each month. Now, you'll also be required to pay the Jefferson County DW education class an initial evaluation fee of $125 on the day of the plea. And should a further evaluation be needed, you'll be required to pay an additional $50. Now, you'll be required to pay this in monthly installments in the amount of $193 a month. Will you be able to pay the $193 each month?
Yes.
You'll also be required to perform 60 hours of community service, attend and complete a DWI education class, have a drug and alcohol assessment, and you'll be required to install an interlock device on any vehicle that you own or operate. You'll also be required to adhere to the other standard terms and conditions of this probation. Mr. Madeline, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Madeline, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Madeline, this will conclude your case. You're gonna stand on the X next to your attorney. Oh, still working, okay. Just have a seat in the gallery, and then when the court clerk is ready for you, she's gonna ask you to come up to the window. Okay.
Thank you, Judge.
Okay, and you once you finish here, Mr. Manley, you'll be free to go, and you have a blessed day, and Ms. Manley, you have a blessed day as well.
Who was the, VA?
With this case?
Yes.
Hofbauer, Corby Hofbauer.
No, on, Crystal Brown.
Was it Lamar?
Brown was Lamar.
Yeah, you would have prosecutor on Crystal Brown case. Okay. Okay, she just needed to know who the prosecutor was. Yeah, is it pertaining to a case?
Well, it's my client had felony, we're done over there, and I didn't know if he needed to
Yeah.
check in here again. Or-
Yeah, okay, yeah.
The felony's, court date is not going to be,
Okay, just have him to come on in if you want to.
Yeah. June
Okay, is that
16th.
Max Lincoln's? Lincoln,
Lincoln.
Linthicum. Mr. Linthicum, please come forward. This is cause number M 333 440, case of Style of State of Texas versus Max Oren Linthicum. Mr. Linthicum, is that your full name?
Yes,
How are you doing, Mr. Linthicum?
I'm doing fine, thank you.
I'm doing, well, that's good. Now, Mr. Linthicum, you're here represented by your attorney, Attorney Dustin Galmore. Attorney Galmore, how are you doing?
Great, Judge, how are you?
I'm doing fine. Mr. Galmore, what is your announcement in Mr. Linthicum's case?
Just like to keep this with the felony. The felony was reset to June, criminal district court.
It was reset to June?
to June.
June, do you know the date?
I believe it was June 16th. But it's not entered in the computer yet.
Okay, so we'll reset it and give it the same court date. Okay, so Mr. Linthicum, your case is gonna be reset on the same date with your felony case. Stay in contact with your attorney, your bondsman. You're free to go. And you have a blessed day.
Thank you, Judge.
And Mr. Galmore, is he on the case?
Yes,
Judge, I'm just checking, see if you got bond conditions already on.
Yeah, he does. He's got a breath machine. And he's got extended rules on blowing into it by the criminal district court.
That's fine.
Yeah, this is just a DWS. Okay,
Thank you, Judge. Thank you.
all right, you are. Next case is called number M 333 case of Style of State of Texas versus Greg Allen Kramer. Is that Mr. Matuska's case? Mr. Kramer is present? He was here. He answered. Could you?
Yes, felony.
Oh,
His name came up in felony court. He may not have known to come here afterwards because I definitely saw him in felony court.
okay. Well, we'll give you an opportunity to, yeah, he checked in.
CDC, Your Honor.
Okay.
Ms. Brown?
What we'll do, did you get that? Did you get that motion
Yes, sir.
from the,
The
Court is in session and cause numbers M, oh, he has to put it, they accepted it without the M, okay.
There's 311 and 313 on there.
No, I'm saying they accepted it without him having the M in front of it.
Well, what I thought, what I would put it down.
Yeah. The court is in session and cause number M321311 and cause number M321313, both cases. Hostile to state of Texas versus Eustace Evander Archibald. Mr. Archibald case is set for trial on Monday, April 10th. And I have Mr. Archibald is represented in this case by attorney Ryan Matuska. Mr. Matuska, how are you doing?
We're now.
Good morning. And the state represented again by attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm well, yeah.
Mr. Matuska has filed a motion for continuances in each one of these cases on behalf of Mr. Archibald. State, have you received a copy of the motions?
I have you on.
Are you opposed to the motion for continuance?
I have no objection, Your Honor.
Okay, no objection. The court is going to grant motion to continuance in this case. Now, I note here that Mr. Archibald lives in Tennessee. Is that correct, Mr. Matuska?
Yes, sir.
Do we need a preferential setting
Yes, sir.
on this case?
Push that in the order too, Your Honor.
Okay. Okay, we're gonna give him a number one setting. Make sure we have on our trial date. Okay, the motion's been granted. We're gonna give you a number one setting.
Thank you.
Okay.
Judge,
Yes.
on Maddie, did you say that?
Jefferson County Court of Law number 2 is back in session. The court is in session in 5 cases. First case is cause number M323858, cause number M327190, cause number M327192, cause number M327194, and cause number M329836. All 5 cases are styled the state of Texas versus Mark Zachary Bender. Mr. Bender, how are you doing? I'm doing fine. Thanks for asking. Mr. Bender, you're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
Great, Judge, thank you.
And Mr. Gertz, what is your announcement in Mr. Bender's cases?
Judge, we're asking that these cases be reset to line up with his felonies, which my understanding is have been reset to April the 27th.
April the 27th? Okay, these cases are going to be reset with your felony cases set for April 27th.
I'm not sure that it's right. I don't, you know,
Why don't you just let me wait?
okay, yeah.
Okay.
That'd be preferable.
Okay, so Mr. Bender, you're gonna reset your misdemeanor cases with your felony case. Our court clerk is going to check the system to find out when your felony date is. And so at this time, stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day. All right. Okay, yes.
Mr. Kramer's status, he just got sentenced to prison time. He's holding cell. I think they're gonna dismiss this.
Good.
Okay,
I'll go check and make sure that it's the same as our current office days and that, I'm saying it's nothing.
okay, if it's not, then we need to hold Mr. Kramer. We could do him today before they send him up.
Yeah, but, I mean, if it's like it, I'm just double checking.
Okay, but make sure, Mr. Porter, make sure that they don't send Mr. Kramer back yet. He's over on the felony side or he's on his side. Next case is cause number M331964. Case is style of state of Texas versus Gabriel Cody Heckerman. Mr. Heckerman, would you please raise your right hand? Mr. Heckerman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Now, Mr. Heckerman, your full name is Gabriel Cody Heckerman. How you doing, Mr. Heckerman? I'm doing fine. Thanks for asking. Mr. Heckerman, you're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, what is your announcement in Mr. Heckerman's case?
Did we, for whatever reason, still don't have discovery in this case? I'm not sure what the issue is, but I'm sure it's just the transition, the computer position. So if we could have maybe a 60-day reset to get discovery, review the videos, et cetera.
Judge, and this is my side of my case, I will tell the court that I'm gonna have to get a transfer to Mr. Johnson because I'm confident.
Okay,
I grew up with Mr. Heckerman.
okay.
So-
So Mr. Johnson is gonna handle the case. Okay. So, no, he said,
It's not very conflicting.
Mr. Johnson, Lamar Johnson, the prosecutor is gonna handle the case.
Oh,
Now, what is,
It's just assigned to me, but it was. So,
you just have to be reassigned.
understood.
Now, give us a reset date. You need about 60 days. Is that correct?
Yes.
Okay, this case is going to be reset to June 14th. Mr. Heckerman, your attorney is going to get your reset. Once you get your reset from your attorney, you'll be free to go stay in contact with your attorney and your bondsman, and you have a blessed day. Thank you.
You know how much I like change? We don't do this. And we've got ends in the bottom.
Okay, Mr. Nolan. I apologize, just make sure to report to the probation office that attached the map on how to get there. As soon as you-
Next case is cause number M 333-220. Case is filed in the state of Texas versus Michelle Alexandra Coon. For the record, your full name is Michelle Alexandra Coon.
Yes, sir.
How you doing, Ms. Coon?
I'm doing well.
I'm doing fine. Thanks for asking, Ms. Coon. You're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, what is your announcement in Ms. Coon's case?
Judge, we're asking for some additional time in this case for discovery review. Do believe we have everything now that we need in terms of video and lab report. We may be requesting additional blood discovery, but at this time I haven't had a chance to go through the more in-depth records to make that decision if we need.
Okay,
Sure, that would be great. Thank you.
okay, June 14th of 2023. Ms. Coon, your case is being reset to June 14th of 2023. Your attorney, Mr. Gertz, is going to sign for your reset. Once he gives you the reset, you'll be free to go and you have a blessed day.
Thank you.
And Mr. Gertz, I think this is your last case. Yeah, one more.
Cody C's.
Oh, okay. This is cause number M 333-626. Case of Style Texas versus Cody Charles Cian. Is it Cian or say?
Either way. I need to-
Oh, how do you pronounce it?
See,
C?
yeah,
C. All right, now, Mr. C, how are you doing?
they're good, Your Honor, how are you?
I'm doing fine. Thanks for asking. Mr. C, you're here represented by your attorney, Mr. Ryan Gertz. Mr. Gertz, what is your announcement in Mr. C's case?
Judge, we've just gotten discovery recently through the new system. In this case, we'd have for 60 days unless have not had a chance to review it at all.
Is that June 14th date?
That's right.
You're still good? Okay. Case will be reset to June 14th, Mr. C. Your attorney's gonna sign for your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Okay, you do this.
All right, thank you. And you'll be free to go as well, Mr. Gertz, and you have a blessed day.
Thanks, Judge.
You're welcome.
Oh. Oh, you said my name. Oh.
Is it? Oh,
Going on?
no, I was looking for my old code.
I have one.
Is it here? Here it is. I think this is just the one. All marked up. Yeah. The 2A, okay, here we go.
What is the, is it on the docket?
No, I think it's.
Statute.
I see. I'll figure out what the issue was. Because we're gonna do that. Thank you.
Sounds good, thank you.
Oh, there it is, right there. That's it. Yeah, I was looking at this here case. I noticed here that he was charged with a driving while intoxicated with an alcohol concentration level of 4.15 or more. State is waiving the enhancer paragraph. And he has to be a Class B misdemeanor, DWI. What I was doing, I was looking at the statute. Yes. And the statute I was looking for, I found was, I think y'all was, I think the state is gonna be requesting, offering that he be given a deferred adjudication for this DWI, is that correct?
That's the right one.
And I was looking at the statute. Hold on a minute. Which governs deferred adjudication in the event in a DWI case. And the statute is 42A.102 of section one, well, basically, let me see how I can do this. B1 and B2, let's see. Okay, yeah, B1 and B2, let's see. In all cases, a judge may grant deferred adjudicated supervision unless one, the defendant is charged with an offense, and they have A under section A or 20A02, that doesn't apply, or the B section is under section 49.04 or 4906 penal code. And at the time, or first of all, this offense is under 4904 of the Texas. Let's see. $49.04. Yes. This is under, let's see, 4904 of the Texas Penal Code. Let's see, a person consumption, it's provided that section 4909. And let's see if they had it will be under 49.04 of the Texas Penal Code. And it says under section 4904, and at the time of the offense, the defendant held a commercial driver's license. I don't know if he does or not. And or the alcohol concentration as defined by section 4901 of the penal code was a 0.15 or more. The court take to just notice of the complaint or the PC or the affidavit. I think his blood, the BAC was 0.199. Is that correct?
Yes, sir, Your Honor, but we're not offering, I do understand that it has to be, for the defendant to be convicted of a DWI offense to get the Class A punishment, it has to be shown at trial that, that the BAC was, a 0.15.
Where does it say it has to be shown at trial?
It'd be 4904D, Judge.
49, oh,
So in the penal code section 4D 4904D.
okay, hold on a minute. 49. 49. Oh,
4904 would be the DWI first statute.
okay, 49, hold on,
Would be the
no.
105 enhancement portion.
Yeah, I noticed the 105, but I was saying that this particular section that governs the eligibility of a deferred adjudication says that under section, under 42A.102, section B1, B, it says, well, I'm gonna say, I'll just read the B portion and I'll go to the 1B. So to be, if I read section 42A.102B and subsection 1B, it would read as follows. I say in all other cases, the judge may grant deferred adjudication probation, community service, excuse me, unless B under section 4904 or 4906 penal code, and at the time of the offense, the defendant held a commercial driver's license or a commercial learner's permit, or the defendant's alcohol concentration as defined by section 4901 penal code was a 0.15 or more. And the way that I'm reading this is 4904D is under the section of 49.04. So just a literal interpretation suggests that if the offense is under 49.04, whether it's 4904 A, B, C, or D, if a person has the defendant's alcohol concentration as defined by 4901 was 0.15 or more, the person is not eligible for deferred.
Right, and Judge, I think that
I understand how you could read to that conclusion. However, I believe the way the statute is reading is that so long as the state proceeds on a class B misdemeanor, development and abandons that 0.15,
Well-
which that requires the state to prove at trial, that the 0.15.
Yeah,
then it
but-
would be subject to the class A punishment range versus what the state's proceeding on right now, which is a simple class B misdemeanor without the 0.15 enhancement.
Okay, and also, Your Honor, for the evidence to support our plea, there has to be the evidence of the 0.15. We're abandoning that enhancement paragraph in the information, Your Honor, and we're also, and it's also guilty plea, Your Honor, and I'm not offering it into evidence, a probable cause affidavit or any evidence supporting a 0.15 going on. It's the charge is, there isn't a separate offense for a DWI enhanced, Your Honor. The charge is a DWI, and if you have the evidence to support a 0.15 showing, then that can be used to enhance the punishment to a class A. But if you don't have that evidence and the state isn't offering that evidence, and I assume that defense isn't either, Your Honor, that we wouldn't have any evidence to support a finding, or to support a plea of a DWI enhanced or a punishment range of an enhanced. We just wouldn't have the evidence to support that conviction.
Okay, now you said that it has to be at the time of trial. The statute says at the time of offense.
Not that at this time of trial, Your Honor, but it has to be shown that there has to be some type of evidence that.
I mean, the court can take judicial notice of his file.
Yes, sir, Your Honor, but that isn't part of our plea agreement. I understand.
I mean, the court could take judicial notice of the file irregardless of whether, I mean, on its sua sponte.
Sure, Your Honor, but that's just not, we're just not pleading to, that's just not the offense that we're pleading to. I
think from what I'm reading, they could have, when they drafted the statute, okay, they could have said, in all the cases, the judge may grant deferred adjudication, community supervision, unless they could have said B under section 49.04 D, which would be at 0.15 or more. They didn't say that. They just said 49.04. And what's inclusive on the 49.04 is the class B, DWI, and the 0.15 or more. It also has the one with the, let's see, the B section. Okay, let's see. I think it's that the open container, it would be the C section. So I mean, when they drafted the statute, the way it reads, it includes the B, the open container, the 0.15 or more, which is the class A, DAC. So the way it reads, it includes that when it says 49.04. The statute does not say 49.04 D. So I'm just saying, and courts are, you look at the literal interpretation, it say, in an attempt to determine or discern collective legislative intent or purpose when interpreting statutes, the court necessarily must focus its intent on literal, the literal text of the statute in question and attempts to discern its fair and objective meaning of the text at the time of its enactment. So I'm just saying, from the literal interpretation, it seems to suggest to this court that the court does not have the authority to grant a deferred um, based on the way the statute is written. And of course, if the court, let's say the court grants a deferred, and if the court does not have the authority, is authorized by statute to grant the deferred in this case, that order of the judgment is void. And the sentencing would be void as well. So
Well, Your Honor, I would only say that, or I would say in addition to that, I understand the literal reading of the text, Your Honor, but the court also cannot, a plea cannot survive without sufficient evidence, Your Honor. We also can do it another way, Your Honor. We can stipulate to facts and have that to be the evidence, Your Honor. But I mean, if that's what if that's what our offer is, I mean, if that's what our agreement is, if that's the statement of facts, and if we don't have anything on the record or anything supporting that, supporting a 0.15 showing, Your Honor, then it would be just as void as
I think, but I'm just saying you have a probable cause affidavit that has that information in it, which is part of the court's file.
Well, Your Honor, the PC affidavit, just like in a regular file, isn't evidence, Your Honor.
Yeah. What I can do, I think I had this issue come up before. If we can give each side an opportunity to brief it and maybe prepare, case law that you may be able to find on this issue, so that it at least give a little support to your position.
Yes, sir.
But I'm just thinking just from the literal, the case law in terms of how courts are supposed to or required to interpret statutes, it appears that the court is not authorized under these conditions to grant the deferred. Now, if either side is able to find some case law or otherwise, I mean, it could be case law, it could be a AG's opinion. I mean,
Yes, sir.
Something.
I looked at this issue before. So you want a deadline by when you want the part?
No, we'll give you as much time as y'all need. I mean, I don't know. We give a standard reset. Normally, it'd probably be about 60 days, somewhere in that. Yeah.
Could we just have a moment to confirm?
Yes.
Maybe we sit back.
Yes. Yeah. Okay. We'll put the case on hold.